A meets a girl aged 15 years in park. The actual age of the girl is 15 years. C tells A that C is 16 years of age and she is ill-treated at house by her father and that she would be happy to be taken away from them. Thereafter, A takes the girl to her house and allows her to remain there. A is guilty of what offense? So a girl of 15 years of age has been taken by A to his house, to her house, and A allows her to remain there. What offense has been committed? Yes, what should be the answer? Anyone who wants to answer can switch on the audio and give the answer along with the reasons. Yes, Smita? Section 361. It is kidnapping according to you? You can make yourself audible. Why is it kidnapping? Just because the girl is 15 years of age, that's all? What is the requirement of section 361? Age is of course one of the factors. The age should be under 18 years. If the person being kidnapped is a girl. So 15 years is covered by section 361. What else is required? Is there any other requirement? Section 361. Yes.
Without the consent of her guardian?
Yes. It should be without the consent of the guardian. So yes, in this case also there is no consent of the guardian who happens to be the father. What else is required? The opening line is whoever takes or entices. Isn't it? So what is the meaning of taking a girl or enticing a girl? That is the relevant point which we need to consider here. There is a direct Supreme Court judgment, a well-known judgment, which spells out the requirements of section 361. I'll draw your attention to that judgment. The name of the judgment is Ashwaradarajan. And this is what the Supreme Court said in that case. Yes, we have an answer from Roman which she says that it need not necessarily mean taking by force, isn't it? So in this case, yes, that is also agreed. The element of force need not be there for an offense of kidnapping. But apart from that, what should be there? This is, you are telling me what need not be there. But what is the essential requirement for section 361 to be applied? Taking or enticing, these are the words which have been used, but what is the scope of these words? Yes, so let's go to the judgment. The question in that case was, when a minor willingly accompanies a man, what is the requirement of law to characterize it as kidnapping? In our case also, the girl is a minor, undoubtedly, but she willingly accompanies a man. What is the requirement of law to characterize this act as kidnapping? This is what the court said. It has to be shown that some kind of inducement was held out by the accused person, or there was an active participation by him in the formation of the intention of the minor to leave the house of the guardian. So when the minor leaves the house of the guardian, when she forms the intention of leaving the house of the guardian, was there any inducement beforehand by the accused person? Was there any active participation by the accused beforehand? That is the point to be considered. If before leaving the house of the guardian, there was some kind of inducement by the accused, if there was some active participation in whatever form by the accused, then of course 361 is squarely applicable. Persuasion by the accused person which creates willingness on the part of the minor to be taken out of the keeping of the lawful guardian would be sufficient to attract the section. Persuasion by the accused person, and this persuasion by the accused person must be before the minor leaves the protection of the guardian, before the minor leaves the house of the guardian. So some active participation must be there, some persuasion must be there. The court made it clear in that case that there is a distinction between taking and allowing a minor to accompany a person. The word actually used in section 361 is taking a minor or enticing a minor. So the court says there is a distinction between taking a minor and allowing a minor to accompany. These two expressions are not synonymous. In our case, the facts say that the minor left the protection of the guardian without any persuasion, without any active participation by A. Let's see the facts again. A meets a girl age 15 years in park. So the first time they are meeting is in a park, and there she tells him that she is 16 years of age, etc., and she is ill treated at her house by her father, and that she would be happy to be taken away from them. So she has already left the protection of the guardian, she has already left the house of the guardian, she is in a park, and for the first time A meets her there. So there is no persuasion by A before the minor leaves the house of the guardian. There is no active participation by A before the girl leaves the house of the guardian, and therefore the essential requirement of taking the minor out of the protection of the guardian is not met in this case. So what should be the correct option? First option says A has committed no offense as the girl came with him with her own consent. Now, strictly speaking, this is not correct because the consent of the minor is not a material factor. It is immaterial whether there was consent of the minor or there was no consent from the minor. The consent of the guardian is required, not of the minor concerned. The second option says A has committed no offense as the girl misrepresented her age and A believed her to be of matured age capable of consenting. Third option is A has committed the offense of kidnapping of a minor from the lawful guardian. A has committed the offense of kidnapping and wrongful confinement. We have already ruled out the offense of kidnapping, so C and D options are not available. Out of A and B, A is not very pertinent, so we would go for option B. Alright, option B, A has committed no offense. though it is not happily worded, A believed her to be of matured age, capable of consenting. That also is not the correct way of putting it. The correct answer would be that A has committed no offense because he played no active role before the girl left the house of the guardian. There was no persuasion by him before the girl left the protection of the guardian. But since that option is not there and we have to choose one of the four options given, the option which is nearest to be a correct option is option B. So we'll have to tick this one. Yes, Josna says that misrepresenting the age and maturity aren't clear from the girl's statement. Yes, the girl has misrepresented her age, that's clear, but whether she is mature enough or not, that is not very clear, and that is not the requirement again. The law on section 361 does not talk about maturity of the girl at any stage. What is required is objectively we have to see the actual age of the girl, and secondly whether there was any active participation, whether there was any persuasion by the accused person before the minor left the protection of the guardian. That is the most important aspect to be seen. And therefore, on that interpretation of the word take, which appears in section 361, we would say that no offense has been committed by A. However, the reason why he has committed no offense has not been very clearly spelled out in the options. But since we have to choose one of these options only, therefore we will go for option B.